Hi, friends. I am really ready to go to bed. But right as I'm about to get into bed, something truly, truly delightful happened. I got a email from Michelle Shocked. I made a video response, but it was taking a super long time to upload, so I made it on my phone. So I just decided I'm just gonna live stream right now. I'll make a different video response after I talk it out a little bit, and then I'll upload that one as a video and also send it to her, of course. My email response to her email. Well, let me read you her email first of all. It's your lucky day, schmuck. You've been named as the respondent on a copyright infringement claim. Just imagine the possibilities for YouTube content clickbait now. Won't your subscribers be excited? I dare you to sign and return this waiver of service. I'm so looking forward to this rumble. See you in court, sucker. Michelle Schacht. Of course, she must think I'm a complete fucking moron. The thing she wants me to sign, it waives her requirement to subpoena me. Why would I want to waive that? Make it easier for her? No, I want her to actually subpoena me so I can actually read the actual content of the proceeding launched against me. What this thing says is when you read the thing, it's things like this is not a summons or an official notice from the CCB. Although it has been prepared using a form provided by the CCB, it is a request from the claimant in a proceeding filed with the CCB that to avoid expenses, you waive formal service of the claim and initial notice. Of course, to know what the specifics are of the claim against me, I need to see that claim and get that notice, right? I need to be subpoenaed so I can respond accordingly and make sure that I can depose her when we get to court. She thinks that, I'm gonna get that email and be like, oh my god, I fucked up. I should never have fucked with this woman. She can take me to court. She should have looked into me a little bit, you know? I'm going to tear her to absolute pieces if she follows through on this. Because, first of all, even if she can establish there was a copyright violation, it's absolutely impossible for her to establish that any even speculative harms were incurred by her. The thing was yanked down immediately, which is typically in any kind of copyright infringement thing. If you immediately respond to a takedown notice, that's the end of the proceedings. There's not really any liability to be incurred, right? Um, so there was that. I got a copyright strike and had to go to copyright school, but for YouTube, YouTube punished me, but the courts aren't going to care about that. The strike got wiped because I took the copyright class or whatever, right? It's absolutely impossible for her to establish that somehow violating her copyright is any kind of MO of mine or pattern of behavior. So she can't establish like malfeasance. And the best claim she might possibly make is instantly turned. She could say, what the video was, it was me saying, I can't find this bitch's music on YouTube. I don't know what's going on. She's some kind of copyright Nazi or whatever. But I found it on the Wayback Machine or the Internet Archive, and here's a link to how to get to it. The thing is, she might claim that I was somehow facilitating others in violating her copyright, except it was taken down so immediately that the only possible outcome of it realistically is that it informed her, oh, I need to issue takedown notices to the Internet Archive. So it was just a benefit to her. So what she's trying to do is say, look, I have technically a violation of a copyright. I'm not sure if she actually does have that because I don't remember if there was any clip of her music in it at all. You know, it's like as I planned it, it was just I couldn't find it anywhere. I finally found it. Here's the link. Here it is. Here, but I may have played a few seconds of it, or may have launched when I showed it on the video or something for a few seconds. I'm not sure. Is that a copyright violation? Yes. And she's already had all of her remedies. She issued a takedown notice, which was immediately honored without my involvement at all. YouTube just mad it, you know. And any court's going to say, okay, so what's your further claim here? You know, it's like when you try to sue somebody, you send a demand letter. If they meet your demands, you then don't proceed to sue them, right? That's a refuse to meet your demands. This woman is absolutely insane if she thinks I'm going to be fooled by this bullshit. You needed to look into me a little bit, Michelle Shock. I'm not a dummy like you. Like she thinks that somehow my subscriber is going to be really excited, and this is what I've been waiting for, some kind of compliment with Michelle Shocker, where she's doing that kind of tongue in cheek, because like, see, now look what you got. Now you're going to court. What do you think about that, mister? I'm delighted by it. I'm looking very much forward to being subpoenaed, and I definitely going to respond to the subpoena, and follow through if you do, and see you in court. You know, you don't have any legs to stand on because you don't have any liability. You incurred no liability. I mean, I incurred no liability. You incurred no harm. And any desire of a copyright enforcement body to issue some sort of punitive things against a serial copyright offender, nothing could be further from me even in any kind of conceivable world. If I accidentally played a few seconds of your song, keep in mind, I've got hundreds of my own original songs that I play all the time. I live stream totally original stuff constantly. I never try to make my hay on YouTube with other people's shit. I'm the most creatively prolific person around. And you know, a court is going to see very clearly that this bitch is spitefully trying to file a frivolous lawsuit against me, having incurred no harm from me, because she didn't like my attitude. And obviously, I'm going to embarrass the fuck out of her in court. I mean, I've obviously got to brush up some of my copyright law and see, you know, be able to cite relevant statutes and stuff. But I can't believe she think who would sign this paper and send it back to her? Who? Because it has the word waiver in it. And because it says here, it's like it says, you may opt out of the proceedings if you sign this waiver, and the case will be dismissed without prejudice, which means she can instantly turn around and refile the case. So, I mean, Michelle Shock, I'm not a dummy, okay? So, hey, schmuck, does it look like you bit off more than you could chew? I think it does. You stupid idiot. This is fantastic. I hope you do subpoena me. Based on the fact that you sent me this ridiculous request for a waiver of subpoena, it makes me think you must have some sort of not real desire to subpoena me. If you were serious, I wouldn't have gotten this. I would have just gotten a straight up subpoena. Right? Serious people don't fuck around like this. If you're serious, what I think this is if I signed this, then she would go ahead because it would empower her in specific ways. Obviously, I'm not going to empower her, but she may fall through with the subpoena now because her ego is fucking. God damn, that woman is so defensive and angry and like I haven't thought about that chick in ages, and she's been fuming about it this whole time and trying to come up with some strategy to get back at me. Any objective third party is going to see that for what it is, exactly that. She doesn't like that I made videos to talk shit about her. Copyright thing is her weapon she's going to use to get back at me for talking shit. Since she didn't incur any harms from my purported copyright violation. So, it's going to be fun. The beautiful thing about court is everybody has their turn to speak and ask questions. I wonder what state she's filing from. It may be a federal thing because it's a copyright matter, but it may matter which state she's filing from. Probably not. It would have to be filing a federal civil case, I guess. It may have its own particular classification. I got to do research, obviously. Um, she thinks I'm a tard, obviously. Like, what would possibly make her think I would sign that and send it back to her? She's heard or watched enough of me to hate me. Surely she should have recognized at some point in that viewing that I'm not going to be fooled by that nonsense. Duh. But anyway, I hope she actually screened it. That'd be great. You've been named as a respondent on a copyright infringement claim. As a respondent, huh? Okay. Not a defendant? I mean, not a defendant, but, well, yeah, respondent is a civil equivalent to defendant. Never mind. It's claiming a respondent. She's the right word. Okay, great. So you've named me as the person who's responsible for something, and you're the plaintiff. Great. Fantastic. I'll be curious to hear how you articulate that you haven't already attained your remedy, because you have, and so you're really grasping at legal straws here. I think the bottom line is she'd have to run this shit herself. She's not going to get a lawyer to sign on to take that case. I could say, okay, I'll tell you what. Let's do punitive damages, Michelle Shark. I will pay you 1,000 times the amount of money I made on that video. Okay. I'm pretty damn sure I didn't make anything on it at all. But if it was anything, it was like 1 cent. The thing is, there's the letter of the law and there's the spirit of the law as well. Even if she can nail me as some sort of violation on the letter of the law, then there's a matter of what the law says her remedies are and how it scales them according to the nature, the scope of the violation, right? I need to look into it to see exactly how they parse that out. Like, I'm not 100% sure that, why I am quite sure that it doesn't absolutely necessarily have to be linked to establish financial liability for them to incur damages, but then those would have to be punitive, which would have to show some sort of pattern of malfeasance on my part, some sort of willful intent to um, undermine the effectiveness of her copyright or something like that. Uh, but I have no obligation not to point other people to where they can find her music. I don't know that it's there against her will. I have no way of knowing that. I could, it could very well be that she decided to leave it up there. I found it. She didn't want it on YouTube, but she decided to leave it up there. I found it. I direct people to it. So there's no way to establish any kind of pattern of malfeasance on my part. And the extra beautiful thing is my body of work proves in no uncertain terms that I am the furthest thing in the world from some kind of serial copyright violator. Of course, the court will also find it relevant to note that among the possible remedies she could have chosen, she chose take immediate takedown. She immediately got the result she chose. She could also have chosen to take all the revenue from the video and have me have none of it. If she wanted to. She didn't choose that option. So, having been caught with my proverbial hand in the cookie jar, apparently, since YouTube agreed with her with the copyright violation, so I must have clipped one of those songs or something, you know. Now, how are you going to get adults in a court to take you seriously that you deserve recompense from me for this? Financial recompense. It's either going to have to be because you establish some kind of liability, articulable financial losses, or because you need punitive damages because I'm a serial harasser, copyright harasser of some sort. But me busting your chops with the truth on YouTube is not defamation. It's you earning your just desserts for being such a country without a reed. Since I incurred that copyright strike, I have not gotten near any Michelle Shock material whatsoever. I've talked shit about her because I'm honestly describing her and her bad behavior, and we should condemn her for it. So, yeah, it's like if she thinks she can control the narrative in court, given the facts as they are, she's nuts. I mean, she may well be nuts. I don't know. But I mean, in the colloquial sense, she's wildly ill-advised in her decision making. You picked the wrong guy, Michelle Shock. I'm sure that can work on lots of people and stuff, but I just find it absolutely delightful. I so pray to get a subpoena here at my house. Email me if you want my mailing address, and I'll give it to you, and you can subpoena me at it. But I'm not going to do your work for you. You got to ask me for my mailing address, of course. You shady, underhanded person that is trying to get me to sign this stupid thing. What if I were dumb and I actually signed it? How could you even live with yourself? I mean, have some fucking character, woman. You know? For Christ's sakes. Trying to slippery, deceive dumb people and get them in an advantageous position where you can relaunch the lawsuit as soon as it's dismissed without prejudice. How can you look at yourself in the mirror in the morning with that kind of backhanded bullshit, legalese meaning very little, trying to intimate something significant? You know, do your job, Michelle Shocked. Subpoena me. Boy, this woman's a real fucking piece of work, I tell you. Can you believe that? It's fucking fantastic. Yeah, in court, call a sucker, she says. I'm not a sucker, though, Michelle Shocked. Yes, you'll see me in court if you follow through on this. But you'll discover, if you watch any of this video, you've already discovered I'm no sucker. If I were a sucker, I would have signed your fucking waiver. And when idiots bluff with legalese, they expect people to just fold. Oh my God, I can't possibly get involved in a court proceeding. I can. I got all the time in the world. I love that shit. It'd be fantastic. Who knows, Michelle Shock, you might even win. Win a settlement of $1 or something. And of course, I may very well countersue for a frivolous lawsuit because, I probably have to take it up in a separate court, but I certainly have a much better case than you do. Everything about this is as frivolous as it can be. You're spitefully trying to scare me with threats of taking me to court. And because you're so spiteful, now that I've called you on it, I think you actually are going to subpoena me. And I'm going to get to fly someplace like to Washington, D.C. or something. Oh my God, this is going to be the most epic fucking YouTube arc ever. Everybody loves to see somebody who's up way too high on their fucking horse, like Michelle Shock. People might think I'm arrogant or whatever, but I don't act like that. Everybody wants to see this, whirling dervish of cunthood taken down a notch. I'll ask, or they won't allow it, but I'll request that the court let me film it. They won't allow it, but you can try to ask. I'll say, well, like my point, Your Honor, is I would love this entire proceeding to be transparent. I believe I'm I was guilty of it, doing something that I needed to remedy immediately, but I did, or YouTube did it for me. So why she should think there'd be additional remedy available to her without being able to articulate any harm, your guess is as good as mine, Your Honor. I think what this lawsuit is really motivated by is spite. She doesn't like the fact that I call her out on her bullshit. She dislikes that way more than she even disliked me linking to her music. She doesn't like how I don't scare her, and how much contempt I hold her in. Well, Michelle Shocked, if you don't want people to hold you in contempt, don't suck so much fucking ass. She's probably like, I'm gonna play this in court. And it's gonna be convincing there too. I mean, I made a video saying, hey, I found this woman's music over here on the Internet Archive. It was up for like one day. I got a copyright strike. It was taken down. I went to copyright school, and I never went near your material again. And you think I owe you something now? You can, like I said, you have 1,000 times the amount of money I made on that video. That extremely punitive multiplier right there. And you'll get at most $1. I don't think I made anything on that video. I'm not even sure if it was monetized. And that's the other thing is like, if the court's going to evaluate whether punitive damages are deserved or something, they're going to look at the totality of my work and see that no, I'm not the kind of candidate for that kind of response at all. So we'll find out what happens. But I'm excited about it. Because, like, what could possibly be the maximum penalty for what I did? It's not like I copied a DVD and sold it or something, I know they can charge you like up to $100,000 fine for that, but that's for commercially profiting off other people's work. And the video in question, to the extent it had any of the work in it, it was just a little bit of a snippet of a song or something. The entirety of the work was my work telling people where to find that. So she is really grasping at straws here. Yeah, it's just about copyright. Well, because, I mean, what she wants to do is, this is my theory anyway, in my opinion, is that she wants to scare me, harm me, put me in my place. She would like to do it for something like defamation, but she has no possible claim there because everything I say about her is true. I'm just relating the shit that happens, And so she realizes, look, I have one legitimate gripe here. It was a copyright violation. So I'm going to get him with that. But she needs to recognize that there needs to be a phase where she evaluated whether that works legally as an argument. But probably she's used to everybody just like crumbling under the threat of court action. A lot of people do. somebody sends you a legalistic looking document that says you're responding in a civil case, people will have sleepless nights, like toss and turn, freak out. Oh my God, not me. This is like wish fulfillment for me. I always have wanted to go into court with the side of justice on my side, and revel in the beautiful accountability mechanism implicit in court. So, you know, if you're going to subpoena me and depose me, I'm going to get to depose you too. And you have to answer my questions. And you can't handle me. You can't even begin to dream of handling me. By the time I'm done deposing you, everyone in the room will either be laughing at you or feeling bad for you. Either way, they won't be thinking that you're going to get a settlement from me. You gotta be so deep in your wishful thinking at that point to proceed with that. I don't know what to do for you. I don't want to do anything for you because I don't like you at all. You're clearly not a good person since you think it's a great idea to threaten a random YouTuber with 8,000 subs with federal action on a copyright violation. It's like, get with the times, idiot. You know, everyone's media is most well served when it's most well shared. You're not benefiting from not being on YouTube. You could put your songs on YouTube and get money from it. Instead, you've gone caveman or something. I don't know. Regardless, nobody's disputing that I have to respect your wishes when you inform me that that's your copyrighted stuff and I have to take it down. And that happened with lightning quickness. So the natural question that the judges are going to ask is, I'm going to ask, or any sane person is going to ask is, so what more do you want? You want money from him? For what exactly? You know? It's one of those things that there's a standard, you know? They look at multiple factors when determining how to evaluate this instance that might uh, tick off a certain boxes, you know, some kind of copyright violation. They don't treat all copyright violations the same. Obviously, they evaluate the nature of the instance on its merits. In this instance, you've got a regular guy who just made a YouTube video, you know, and immediately obeyed the takedown notice. And then you got this crazy bitch who wasn't satisfied with that and wants to go after this little YouTuber, even though she's famous, actually famous, and I'm completely unknown. You know, I disagree with her about her perspective on copyright. That's why she wants to sue me. Because even though I disagree with it, I obeyed it. So let's see what happens. Once I see the subpoena, I'll know a lot more because it'll have specific language explaining what they're purported, what they want, what they're asking for, whatever. So my favorite part of the whole thing is that she thought I was gonna sign that, or there was some possibility that I was gonna sign that. Like, how little did she think of me? Did she think I'm that dumb? I just got reminded by um, well, yeah, misdemeanors can be sentenced to a maximum of 1 year and can be fined a maximum of $100,000. Sure, but the thing is, one imagines for this maximum penalty what would comprise a maximum copyright violation. That would be somebody making copies of your music and then selling it as your own or something, or being a like an industrial sized DVD counterfeiter, selling those kind of things. That's what you're looking at for those kind of penalties, right? Some maximally brazen and ill-intentioned, purposeful profiting off somebody else's copyright. That's not what happened here. If obviously I want to go to court and find out what happens. I'm not really worried about the like say getting penalized because the thing is what this law here says is for criminal offenses. What she didn't say defendant, she said respondent. It means she's treating it as a civil affair. In other words, I'm not subject to that law you're talking about, Winston's mom. That's for serial copyright offenders, people who are using copyright violation as a means to profit consistently and regularly. And that would be fine. Just so I could have material to, well, sure, she could try to sue me for damages, either punitive or literal. She can't establish any actual monetary harms because it's not like I made it such that people could briefly download her song from my YouTube page and she lost a few sales or something. Nothing like that is even conceivable. So you can't establish actual financial losses. And in fact, even if I had intended to point people to her songs on the Internet Archive in order to empower them to violate her copyright, it didn't work out like that at all because it was taken down right away. And she was immediately aware of it, the video. All it did was inform her that she had missed a couple of spots and allowed her to take those videos down. So if you're going to be counting financial impacts, she should be paying me money for helping her. If you're counting punitive damages, well, then you need to establish more than Eric whoops a copyright thing that's normalized against with most everybody else on YouTube. You know, because everybody has the option to, instead of taking something down, claim all the money from it. Any sane person would just choose to do that. But the point is, I'll be able to establish she's already enjoyed one concrete remedy, one and a half, you might say, and that any additional remedies would need to take place as either actual harms or punitive damages. To acquire punitive damages, she'd have to show a pattern of bad behavior on my part. Again, the way she's putting this out there, she's not positioning me as a defendant, so I'm not subject to those criminal penalties. B. As part of the final judgment or decree, the court may order the destruction or other reasonable disposition of all copies or phone records found to have been made or used in violation of the copyright owner's exclusive rights. I have not anything at all of hers. I have no access to the video that purportedly violates her copyright, so I can't verify that it actually does even. I'm assuming it does since YouTube sided with her, but I suspect YouTube sided with her sort of immediately because she's such a problem about copyright, you know? If she could, she'd make me talking about her a copyright violation because I'm using her name. Of course, that's not going to ever fly, but she would love to be able to do that. The way I read this thing is this woman absolutely hates me because I'm not scared by her insanity. And she's experienced everybody else being scared by it, intimidated, you know? She doesn't intimidate me at all because, after all, at this point, I'm in the right. You know? Let me look at this link. This is a great link. Thank you. So here are the actual damages that are available. Remedies for infringement, damages and profits. A. In general, except as otherwise provided by this title, an infringer of copyright is liable for either 1. The copyright owner's actual damages, which we've established are zero, and any additional profits to the infringer, which we've established are zero, as provided by subsection B, or 2. Statutory damages as provided by subsection C. So, subsection B, actual damages and profits. The copyright owner is entitled to recover the actual damages suffered by him or her as a result of the infringement and any profits of the infringer that are attributable to the infringement and are not taken into account in computing the actual damages. In establishing the infringer's profits, the copyright owner is required to present proof only of the infringer's gross revenue, and the infringer is required to prove his or her deductible expenses and the elements of profit attributable to factors other than the copyrighted work. That's very simple with YouTube. They have a record of how much every video made. And since I don't rely on her in any way, shape, or form to get my channel rolling or give me people to be interested in, she's not a subject of conversation very often, anything like that. She's dead in the water. Now let's look at the statutory damages. Except as provided by Clause 2 of this subsection, the copyright owner may elect at any time before final judgment is rendered to recover instead of actual damages and profits an award of statutory damages for all infringements involved in the action with respect to any one work for which any one infringer is liable individually or for which any two or more infringers are liable jointly and severally in a sum of not less than $750 or more than $30,000 as the court considers just. For the purposes of this subsection, all the parts of a compilation or derivative work constitute one work. Okay. So here's this part. In a case where the infringer sustains the burden of proving, and the court finds that such an infringer was not aware and had no reason to believe that his or her acts consulted an infringement of copyright, which is very accurately the case in my instance because I believed I was making a video just to show people where it was. I may have accidentally included a snippet of the song, but I was certainly trying not to willfully infringe her copyright, but to direct people to where they could find her music because I couldn't find it. I did the same thing with an app I couldn't find. And then when I finally found it, I made a video saying, here's what it is. If you've been looking for this and I couldn't find it, you couldn't find it like me. Here's where it is. Okay, so in such an instance like that, it says here, the court, in its discretion, may reduce the or statutory damages to a sum of not less than $200. The court shall remit statutory damages in any case where an infringer believed and had reasonable grounds for believing that his or her use of the copyrighted work was a fair use. Under Section 107, if the infringer was an employer agent of a nonprofit, and various other things. The point is, when you look at this, it's very clear that basically in any civil action, the court, in its discretion, may allow the recovery of full costs by or against any party other than the United States. In other words, you can get There's a lot of stuff to this. She basically has to win the argument as to whether I willfully violated her copyright. If she can win that argument, she might get some damages. Let's see here. This is stuff for service providers. Oh, there's a lot of stuff here. The point is, if the court determines that a copyright infringement occurred, I'm not convinced one did, because I have to admit, I don't know for sure if there's any of her music in it. But let's say the court agrees a copyright infringement occurred. The worst case scenario, based on my reading of this, is that I have to pay her $200 under statutory damages. It's conceivable they make me pay her lawyer's fees and stuff, but well, it'll be interesting, you know. It'll be worth it, whatever happens, because it should be pretty clear to everybody there when they hear all the details of this thing that this woman is launching this lawsuit out of spite. There are no actual harm she incurred at all. So the only kind of damages you can get are statutory. And those statutory damages are contingent upon your relationship with the breaking of the law. Mine is as mild as it could possibly be. I don't think I should be liable for her lawyer's fees and shit. Because I mean, we shouldn't reward that kind of frivolous litigiousness. You know, she's doing it right. She has a single bullet, you know. That's how you gotta do law stuff. But human beings are human beings. And judges don't like having their time wasted by people who want to get back at some random YouTuber because you don't like his attitude. I don't think she's gonna even win at all, but I could see myself losing a $200 statutory judgment, conceivably. I mean, the thing that's most notable, of course, is that to the extent that they see my pointing people towards her copyrighted stuff as somehow facilitating copyright infringement, the problem they have is that the actual outcome of it was that she learned that those things were there and that she wanted taken down but didn't know about. Removed those things, and thereby, to the extent she incurred any harm from people listening to those on the Internet Archive, well, that video saves her from those harms. It didn't magnify them. You know, it's just. Well, if she were to win a judgment, and I don't really see how she could actually, because she'd have to win the fact that I willfully violated her copyright. You might be able to make the argument that I willfully tried to undermine her copyright um, extremism, but that's not actually violating the copyright willfully. And unless it says clear cut in the video, which of course I don't have access to, the Discovery will let me see that at a time that I say, let me just play a few seconds of this. Even then, at the time, I may have very well been still under the impression that things under a certain number of seconds didn't violate copyright. I was wrong, but that would comprise ample reason to believe that it's not a willful copyright violation. At which point you can't get statutory damages. You only get statutory damages under a willful copyright violation. And the actual damages are 0. And if you don't win the case, you can't be afforded attorney's fees. So it's all going to hinge on whether she can establish that I willfully violated her copyright rather than did so in my sloppiness, I don't think she can win that point, so she'll lose the case. If she loses the case, then I will ask the judges to make her pay all of my expenses. I won't have any attorneys, but I'll have travel expenses and stuff, Meanwhile, she's still driven by rage, but now I'm finding this interesting, having read all this shit, The thing is, if you don't really believe in TI or don't trust it, you'd be very scared by what I just read. But oh, I see what that is. I was like, who's that talking? It's me. I'm hearing from Rachel upstairs, I think. So, the thing is, she's fought copyright battles before against record companies and stuff, right? Who actually she had a real case against. Copyright courts see real cases where somebody's actually been subjected to copyright violation. Know what that looks like, When they see me and they see the totality of evidence against me, they're gonna be like, are you actually trying to sue him? Of course, I already got the briefs written as blocks basically in my head. Whatever Pina says, I have to figure out the procedures of when to submit motions and stuff like that, but motion to dismiss at the gate, she can't meet her prima facie burden. She needs to establish either she's eligible for actual damages or statutory damages. She can't establish either of those things, so she can't possibly win the case, so dismiss. you know, I'll quote the case law that Mr. Vaughn so conveniently links to me there. Brr, it's cold. I'm already thinking of some other great arguments too. They're drawn from the service provider liability section. Basically, like, by agreeing to YouTube's terms of service, I am conferring on them power as my agent to immediately remove any copyright violations. So, in other words, instead of that process protecting the service provider, protect me by the power of commutative property. If argued properly, it should withstand water. Anyway, this is fun and interesting. I hope she actually does the funeral. I mean, the worst case scenario wouldn't cost enough to make it not worth it for me, you know. I mean, the thing is, there is a distinction between the letter of the law and the spirit of the law. This law was never intended to be used by people like her against people like me. And all of the judges with legal minds in the room will hear that statement, understand what I mean, recognize it is so, and also acknowledge it's not determinant of the question, you know. But it's one of a number of various factors. There's discretion afforded to judges in very specific areas that are delineated here. And that's where she's going to lose. The judges have sufficient discretion about sufficient things, such as determining whether something's willful or not. And it describes the evidentiary burdens for both sides as well. The burden's actually on the respondent, just shows that it wasn't willful, sort of, but not really. Yeah, I mean, she thinks she's getting me. She is getting me in a very good mood. Yeah, I can see, the arguments in this thing are cascading already, and I'm noting which kinds of things are protected speech and therefore you can't be civilly liable for them. Some of the stuff I've said qualifies as protected speech. So if she's gonna make certain kinds of arguments, this is gonna be fucking fantastic. This is like a YouTube dream come true. What happens, Michelle, shocked, is the person you're trying to share, 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 is the person is absolutely delighted by the prospect of going to court. Because there's no way anybody in that proceeding is going to interpret it as anything but her being wildly vindictive over nothing. But the judges may nevertheless feel like their hands are tied by certain things and can't adjudicate the case based on them. That's fine. I recognize that. But at the end of the day, like I said, because the areas that are carved up for judicial discretion, she's not going to win. You know, smart people, reasonable people can see when somebody's not motivated by justice. You know, for whom would justice be attained if they ruled in her favor? It wouldn't be a just outcome. You know, she basically would have been exploiting an incidental mini clip of her song that hypothetically is there, I guess. I'm not sure, but in order to punish me for speaking out against her position on copyright. That's protected speech. And at that point, you should potentially start like countersuing for some kind of frivolous lawsuit thing or something. I'm not sure how that would work. I don't really plan to do anything like that, but I do plan to have a wonderful time keeping everybody updated as realities emerge, you know. Of course, before I can really know exactly how to roll with this, I'm going to need in some kind of disclosure to get a copy of the video that reportedly violates her copyright. I don't have any copy of it. And disclosure will allow both parties to be fully informed as to what that exactly says. You know, the exact verbiage I use in it and whether there's verbiage about the fact that I'm playing this little clip, if I do, that's going to make a big difference, you know? So it'll be interesting to see what happens. You know, she might be able to get something out of this from me. But I like my chances. You know, even if she does get something out of me, it's like I won't feel like I've lost, really. I'll feel like, okay, well, that was expensive fun. You know? Anyhow, it's an exciting end to an exciting day. I was like knocked out, like falling asleep, about to just pass out. And then Rachel tells me, I got some bad news. Michelle Shocked emailed you. She's suing you or something. And I'm like, really? I read the thing and I realized, oh God, what a fucking underhanded ploy she's trying to pull. Get you to waive the need to subpoena you, and then she can just reopen the case as soon as it gets dismissed without prejudice. That's so scummy. Well, no, that's not how it's going. You formally subpoena me so I can read all the documents. All right. Well, that's gonna be it for this live stream. Hopefully, Michelle Shocks watches it. Um, it's like I wonder if she does watch the. I wonder most of all what she thinks about my point that like even if she were to win, this is only gonna play as spiteful, vindictive pettiness on your part to any person who cares at all about the truth or even cares at all about social grace, about fairness, about anything like that, right? It's like you're a celebrity who's suing me because I was trying to direct people to where your music is online. Which I was doing because I actually like your music a lot. I think you're quite good. And I don't approve of your weird, you can only get music by buying CDs from me thing. I think it's incredibly stupid. But I respect your copyright, obviously, since I've made zero effort at all to put any even one note of your music up since that happened. I mean, you're clearly, even though I'm going to be bullying you low key because I'm right and just and true and good and honest, and you are a piece of work, um, you're going to be perceived as bullying me. It's unavoidable. It's like, why is this famous person not satisfied with an immediately obeyed takedown notice and him getting punished by YouTube and him never doing anything like that again and having no pattern of malfeasance whatsoever? How could that be not enough to satisfy this woman? It's not like this Eric guy's famous like this woman is. It's not going to play well. I mean, she obviously doesn't care about how she plays in that regard at all because otherwise she wouldn't be devoting so much energy to spiteful meanings. But the problem she's going to have is it doesn't just play to my YouTube audience or maybe an expanded YouTube audience interested in the story or something, which I'm sure she thinks is my number one priority, which of course it is not. But um, it's going to play to the people in the court a certain way. Nobody's going to be very sympathetic to her because my story is I like this lady's music. I wanted to listen to it. I couldn't find it online anywhere on YouTube. So I Googled stuff and I found it on Internet Archive. So I made a video going, hey, I found it. Here it is. Look. I have, at that point, no way I could possibly know whether she knew about that, was okay with it being there, or believed that it should be immediately taken down because of a copyright violation. Regardless, it proves that she's suing me while the Internet Archive is a place that actually had her shit up. But she's suing Eric. I mean, I wouldn't be surprised if she's suing the Internet Archive too. But I don't think she'll get anywhere at all with that because it's literally impossible with that to establish as a willful copyright violation. And on the other hand, she could get actual harms potentially, but she'd have to get data about how many times the thing was downloaded or something like that. Regardless, if she goes through with it, it should be fascinating. I'm not worried because I know I didn't do anything that wrong. You know, I might have technically violated her copyright, but I'm not the kind of guy the courts are looking to punish for copyright violations or award damages to somebody else for. Nothing about me and what I do says to the courts, this guy's a copyright problem. So she's going to have to hope that everything gets maximally narrowly construed and they believe to be a willful copyright violation. I mean, the thing is, of course, on YouTube all the time, I encounter copyright issues. YouTube allows me to remove the offending section. It's like background music in a store or something, you know? Or like if I'm singing covers. If I sing certain Billy Joel covers, then Billy Joel gets all the revenue from that video. Even though I'm just covering it. But given the environment I was operating in, my understanding of copyright was shaped by how YouTube was dealing with it. And the way YouTube was dealing with it is you put shit up. If it was somebody else's copyright, then you got notified, oh, you got a copyright thing here. What do you want to do? You want to give them all the money, remove the offending section, take down the video, what? So, even if you could establish there was willfulness somehow in my engagement with the copyright, you'd have to say it wasn't willful copyright violation. so much as it was a sloppiness that I expected, that consistently played out copyright ways that were not this, right? So, for me to willfully violate copyright would mean I behaved differently than how I normally did on YouTube, and also that I knew clearly the distinction between copyright law and the YouTube copyright solution, which affords all the power to the copyright holder, as it should, but what what the way the way it looked architecturally was that meant the copyright holder gets to decide what to do if you don't choose one of your options to solve the problem, you know? So, it's very reasonable to believe that rather than willfully violating copyright, I was just relying on systems that I believed prevented me from violating copyright, not understanding that that order of operations can be subverted. It's going to be very challenging to get past that, you know? Of course, I don't remember exactly what I said on the video, so what I say there is going to be very informative about these matters. But if she subpoenas me, then there'll be discovery and I'll get to see what all of that is. All right. Now I'm getting tired again. So that was fun. But now fun time is over. What does it mean when fun time's over? It means time to go to sleep. I'm taking a Seroquel, which will help me get a good night's rest. Okay, close this tab. Actually, I'll leave that tab open. And don't forget to eat plenty of cheese. Heartburn.